guess I get to sit behind the podium. So nice to meet you guys. Good to see all you guys. And let me start a little bit about my background. I've been in the Valley for 10, 15 years and have done some software development myself. So I've done engineering roles at various enterprise companies, including here in Sunnyvale, up in Palo Alto, up and down the valley. So like a lot of you, I've been going up and down before I started on my legal career. So that's how it's very relevant for you guys. So from my perspective, I'll do limited questions to keep the discussion lively to that extent. But if it gets bogged down in questions, I'll have to defer those questions to after the session, okay? So a little bit of audience participation. And how many of you have not filed a patent? Okay. How about the second question about the number of patents possibly this year? I did that question 6 months ago in my last presentation, and that's the number of you guys raised hands, but I wasn't able to talk to any of you guys within 6 months. But it's good that you guys are planning on doing a possible patent within this year. That's good that's part of the innovative cycle. Okay, how many of you guys have questions on patents? Okay, some. And how about trademarks? Okay, so those are let me go through this. These are the intellectual property protections that are available. Let me see. The patents, trademarks. I'm going to talk primarily on the patents and the trademarks and a little bit of trade secrets, but not much. I don't think I'm going to talk about copyrights. If we run out of time, we'll probably not. We'll just do one slide on trade secrets. Okay? So the definition is patents. It protects your ideas and machines, any of the publicly available claims. The claims are the important things, protect your ideas and machines. And then the trademark protects your brands, especially your company names, URLs. Typically, you guys have the URLs and the company names. They're munched together to have a trademark, and then the trade secret protects a lot of your trade secret sauce that becomes relevant when you don't want to do a patent. You want to protect certain technology that you have, secret ingredients. But in this valley, it's hard to do a trade secret because there's so many engineers moving on from one company to another. Okay, and then copyrights, creative expression. Any of the source code that you have for software, it's creative expression. Okay, and here's a picture of a slide to lock on the iPhone. I don't think this one is that relevant these days because everybody has an unlock portion, so they patented a specific unlock technique, okay? So this is the patent legal rights, and the first one is it prevents others from making or offering the patented invention for sale in the U.S. So it's more prevention for others on your patent. So it's a preventative mechanism, okay? And then it's an exclusionary, it exclude others, but not necessarily affirmative in a sense that unless you have all the patents on the underlying technology, it's not, then you may not be able to make it, but you can have certain pieces of it. Okay? Any questions on that one? Cool. And then these are the types of patents. There's the utility design, and I put the plant patent for completion more so. It's kind of interesting to put it out there. Most of it is the utility patent for this audience. Anybody interested in doing design patent from this group? possibly.
So
Oh,
a general question, what can be patented?
what
What
can,
other things can be patented?
the question is what can be patented? Within the, this is the list of things that can be patented, actually. The articles of manufacture, machine or apparatus, software, programs, technology, any of the composition of matter, living organism, even though this audience isn't specifically for that. And then any manufacturing process or method of doing business, although method of doing business is very small. So software processes can be part of the stuff that can be patented. That's under the utility. And then it says the improvements, any of the improvements. Most of the technologies that you're going to patent are the improvements of any of the innovation.
Software code, patent code.
Yes.
How do you prove that it's, how do you prove
Okay.
not as somebody else's code? Pretty much most of the code is fairly the same.
The question is, how do you prove if the software is patentable? You do a patentability search. Well, that's what the patent office personnel do. They do the search. Patent attorneys, they do the search to see what's the lay of the land. As an innovator, you want to know what your competition is. So you want to look at the various products that are out there. You know who your competition is. The other aspect,
So you patent the code or you patent the functionality?
you patent the functionality and code. The question is, do you patent the code or the functionality? You patent the functionality and code, because code is an embodiment, an implementation. You'll have to do that, because you need an example implementation to make it enablement aspect. So these are the elements of it. So you patent this is a good example, you patent the code to get the best mode, enablement. Where's the enablement? Enable the best mode. So that's the enablement portion, to make it work. So you have to give it to somebody to make that technology work. And in order to do that, you have to show that code, or show. It has to be in English, not source code. So these are the three elements of the patentability. And checking time. Okay. And the novelty, non-obviousness, and best mode. Novelty is it's unique. It's not the actual words are here. The actual language of the law is here. It's just the invention is not anticipated by any single prior art reference, meaning prior art is previous inventions, which discloses every element. So those elements have to be mapping, meaning elements of the claim. So the key is the legal language is in the claim. Not only the specification backs up the claim, and claim represents your idea. We'll go through that again. Then there's the non-obviousness. So your technology has to be an improvement that's not obvious, meaning not obvious to someone of the ordinary skill in the field. That person is, to most of us, is a software developer. So a software developer would look at an idea and say, that's unique. That's new. I haven't seen that before. By looking at all the prior art or any of the prior invention. That's how you would do it. And then you have to describe your best mode, which means that you can't hide back any of your best technology, which is typically what you want to do.
The second bullet makes it very difficult to patent source code.
Not necessarily. Not necessarily. The second bullet, ordinary person of the skill would look at a piece of code, even though it's already been done before, if it's a unique way to do that technology in a new field with new combination. It may be a very narrow patent, but you still may get it, because if it's a It's the breadth or the narrowness of the patent that you're going to get. That's what we're talking about. And then let's go through this. The claims are the invention. That's the legal language that you have to describe your technology in order to get a part of that patent. So the statement, it's a statement of precisely what the inventor regards as the invention. And all the claims are at the back of your specification. You describe your technology in the specification, and then you put a list of claims, which is a description of your idea. And then there's two types. One is the independent claim and the dependent claim. Dependent claim references the independent claim. You can see that apparatus described in claim 1. That's the difference. And then the independent claim has an open claim or closed claim. That means that open claim means it's a broader set of, let's say, process steps. It's more open rather than a narrow version. So the closed claim is a narrow version of your invention claiming. And the open one is more broader in terms of claiming language. And then the last bullet is patent applications get published within 18 months of the filing date. Okay, I'll take your question.
Question regarding that patent secrecy. Does that include provisional patents?
Provisional never sees the end of the. The question refers to the provisional application for secrecy, and the answer is provisional never sees the light of day. It's filed with the patent office. They're not going to disclose it for you. You just reference it when you do.
Wants to file the actual patent, and then it has 18 months of secrecy.
Right. It's based on the earliest filing date, which includes the provisional.
Oh, I see.
Earliest filing date. See, filing date. So, okay, quickly, go ahead.
Could you explain more about open and closed? Why would you use open versus closed?
That's a good comment. The question becomes, why would you use the open or closed claim? Sometimes there's other inventions that's already closely mapped. So you use the closed mechanism to narrow it, specifically narrow it. Right now, most patent attorneys use the open claim. But if you see specific technologies that covers a lot of areas, you want to narrow it, and that's how you would use them.
If you have a new thing, initially you try for open. That's the norm.
Or you see prior art that's covers a lot of area. Then you want to narrow that specific area so that you can get allowance more so. Okay? Let's keep going. Okay, this is the provisional portion. I think this is quite relevant to you guys, more so than a utility, especially if you're bootstrapping. Provisional costs, it's $130 for a small entity or $65 for micro entity. You need some sort of a micro entity certificate, and there's salary certification, and you can't have more than 4 inventions to your name. It's kind of weird, but that's the limit they provide. And then these are the requirements of a provisional. Inventors, detailed descriptions, drawings. You need drawings, detailed description. No claims are needed. Okay? Go ahead.
I was told that I have the idea for 4 patents, that I could write 1 provisional and just cover all 4. That might turn into 4 later.
Yeah, I think you can do that. Then what you can do is to a divisional.
That's to get the $65 version. Yeah.
Right. That's so the comment is that you can combine ideas to put it into provisional. That is the case. But at a certain point, whether you do that when you do the utility or when you do the utility, the patent office will get you to divide it. Hopefully you'll have funding by then, significant amount of funding. That's the reason why you combine it, is to decrease the cost of it, okay? And anything else? Allows patent pending. So that's the key aspect. You get a filing date. The filing date is the key aspect. You can do patent pending on your technology. You tell everybody you're patent pending. Okay?
So while I'm in the period of 12 months, let's say I file for a patent today, and after 6 months, I see an innovation improvement, and I make some improvement to it. What happens to that, and how do we go about with that?
Okay. The question is that if you already filed a provisional and added, let's say, see an innovation in 6 months, what do you do with it? That's where the patent strategy comes on. You have to come up with how you're going to capture it. A lot of times for technology company, they want to capture the innovation at certain time frame, because the innovation doesn't stop at 12-month boundaries or 2-year boundaries. They happens whenever there's inspiration and you implement that. And then what you can do is, one possibility is either file another provisional or just wait and hold it. Because if it's not part of the core patent, then maybe you can hide it for a little bit. Those are things that you have to wait.
So what do you mean by hiding?
Meaning don't tell the world. Because let's say you already did a main provisional, and that's the one that you're going to protect your company off of. So the other ones are not as important, so you can just leave it alone, possibly, and or file another provisional. Those are options that you can talk about. Okay? Anything else? 1 year anniversary, you can do a PCT, International Patent Application, or a regular patent application using the same technology, or any of the publications. That's the unless portion. Okay? Yes.
Is that item 1 at the very bottom?
Yes.
Once I file a provisional, I can write about it and make presentations of it, right?
Yes.
So it says something different.
Um,
Unless it has been fully described in a printed publication. I mean, that means,
yes. That reference to the 1 year time frame. So you have to be careful of it. I think I'm going to talk more about it in the next slide. So we'll talk about that question in the next slide. Okay. The following slide. We'll get to it. The utility patent costs $800 for, actually it's $760, but $400 for microentity. These are the electronic filings. These are the number of claims you can do, independent claims and dependent claims. Independent claims and dependent claims are important because of the charging that the USPTO does, the charging mechanism, how much they charge. Because above this, they'll have additional charges. And the prosecution average is 3.5 years, and utility expires after 20 years of the filing date. Okay? Sure.
When they file the patents, I mean, now they have a prototype, so if you don't have the design, somebody can help you with the design, something like that. And the product is ready, you have the idea, and you need some help to put it in the production. In between, they have a prototype, which actually helps with the design. How long that time period, and do I need the legal documents ready if I share my idea with them?
With who?
With whoever.
Oh, who you're going to do the prototype? Typically, that's covered through NDA. Assumption is that anybody's
Not documented enough?
right. Okay. So if you're doing a prototype, which is an interesting question, and the people, so when you're doing an invention, there's going to be a small group of people that you're going to work with together. Those close collaborators are not part of the publication or giving it out to the world. So those people are covered by, typically by an NDA, non-disclosure agreement. And they're not part of publication or public disclosure. Does that answer the question?
Yes, that answers. One more question. So before that, I need to have the patents ready, or the company has to be filed on the copyright, or this NDA has to take care of it?
And to work with those people, just the NDA.
Yes, yeah.
Right. And you probably want an IP agreement to have it assigned back with those people. Otherwise, they can take the IP and run away. So that's part of your consulting agreement. You'll want to have that. But let's continue on it. Those are very relevant questions, especially when you're developing your technology, how you work with consultants, and so on. So in terms of first to file, you can be the first inventor to file except for some of the disqualifying event. If the technology has been in publication or patent or in some sale or public use, any of those will make it so that you can't patent that technology unless the publication is within that 1 year. So within that 1 year after you did the disclosure, you have the right to patent your technology, okay? And that's what the A and B states. So in essence, if your patent has been in publication or patent or sale, then it needs to be more than a year before you've invented your technology or disclose your technology to the public or tell people about it. Okay? The other thing is that it's in another inventor's public. This is the additional rules. And if the prior invention and the current invention is owned by the same person, level C, then you can invent that. And or the subject matter was disclosed, was obtained from those inventors. So this is a requalification of it. Okay? So these are the ways that people can, when your invention is publicly disclosed. This and prior slides. And the key thing is you have a 1 year to file a patent application after you disclose it. No, whether it's a patent application or some public disclosure or even selling your technology. Okay. I'll go through the rest of it relatively shortly. We have about 15 minutes to close up. So I'll go through it, and if you have any spot questions, we'll do that, and we won't take too much time. And we'll leave the last 7-8 minutes for questions, okay? I want to finish by 1:30. You guys have been sitting here since noon, so we don't want to do that. So Invention is, I presume all of you guys know about it. I'm just putting a word on the process. The definition is determined precisely how the discovered product or technology differs from what is already existing, okay? At the time of the invention, that's the key, at the time and the possible stages of invention is the conception, R&D, and reduction to practice. Reduction to practice is a prototype, as we were chatting a few minutes ago, and or a patent application. It's not necessary, but it really helps the patent application if you have a prototype. And then this is a very important concept, the inventorship. I'll send out the presentation if you ask for me. I'll send it to you so you don't have to take a picture. So this inventor is, there's any natural person for an operative invention, not mere implementation of someone else's ideas. So you have to have a novel idea. And then joint inventor, any amount of collaboration you do with two people. A lot of the stuff that you guys are working on are done by joint inventors. So it's best that you have IP assignment agreement to the company from the joint agreement. Otherwise, it'll be more expensive if you don't do it early rather than later. If an inventor doesn't do an IP assignment, they can each joint inventor has equal rights to practice that. So that's very careful that if you do any patent work or intellectual property and file a patent application, typically on a provisional, you don't do an assignment, but and on the utility, you do an assignment because you want to assign it to the company. If you don't do that, then each inventor owns it and they could practice it. So for example, I can license it and someone else who's joint inventor can license it equally. So there can be 2 licenses, so you can't have exclusivity, so exclusive license. And then this is the software patents. I think this is relevant for this group. And this comes from where a lot of software patents are an abstract idea rather than an invention. And these are the steps to go about to figure out whether it's an invention or not. It's relevant for technologists because they want a software patent rather than make it a abstract idea. If you want to make an abstract idea, you can't get an invention. So the determining factor is that is the claim directed at an abstract idea. Those are it's just an idea rather than a concept or a mathematical principle. And the second consideration is take all the additional elements of it and does it transform to a patent eligible application? Are there more meat to it? So that those are the 2 considerations that came from the Alice case that occurred a couple years ago. Okay, some of the technology that are facially allowed are e-commerce or financial services or gaming. And then claims that are rejected are the finance or business methods. Those are the, finance are on both of the bullets, but the key is that is it a financial method versus some sort of a service or technology that involves some financial components to it. And presumption is directed to abstract ideas. Okay? And the duration of the patent, okay, we're running out of time. So duration of the patent, 20 years, design patent, 14 years. That's not. And then here's some of the fees, filing fees. I think we already talked about it. The only interesting thing is $300 for the publication fee. And the allowance fee when you get a patent issued. Actually, I'd love to pay the $480 allowance fee. That means you're home free on patent application. And this is the maintenance fees. It's good to pay these maintenance fees. That means you have a patent. And then the extension of deadline. Okay? I'll skip this. There are some remedies. Interesting thing about remedy is there's a 6-year statute of limitation, meaning that you have 26 years in order to file for an infringement claim. That's why a lot of old patents, they come after you, even though they're expired within that 6-month time frame. It's a 6-year time frame. So. And those are the interesting things. Let me go through a little bit of the trademarks, and then I don't think I'll have enough time for trade secrets. Trademarks, it's a word, phrase, or even color or sound distinguishing companies' goods or services. Some of the early things that you'll want to think about if you haven't already done that is dealing with the trademark of the company name or web URL. The issues that you have to do is if someone else has a trademark for this, then you'll have to change your company name and or branding. Probably not the company name, but the URL, which is if you've done some marketing work and built up some branding, it's not fun. I've dealt with a couple of issues along this line.
Can you comment on federal versus local trademark issues?
Yeah, the question is about federal or local trademarks issues. The federal Federal is filing the trademark with the trademark office. That is, it's evidence that you filed it. Local means that you just start using the trademark within a certain domain. So it's more of a use rather than filing. And filing it with the trademark office gives you evidence of the fact that you have the trademark.
Filing is always federal, you say?
Yes, filing is always federal.
Why do you think the web URL is going to be an issue? Because the domain is going to be unique, right? I mean, whether you get it or not, if it's already there, you are not going to get it, right? So
Yeah.
that's the thing that you're talking about.
The question is about whether the URL is important or not. It is because if someone else has your web URL as a trademark, then they can make you change the name.
Okay, got it.
That's the bottom line, okay? And this is the requirements of the trademark. It has to be distinctive and used in commerce and or planning on using in commerce. Okay. Trademark qualifies for protection, can be acquired by one or two. Use of the mark in commerce or registered with the U.S. Patent or Trademark Office. Either way will allow you to get the trademark. But the second way gives you more evidence of it. Gives you, and the cost isn't exorbitant. It's not too expensive, less than $1,000. Filing fee is $225 to $325, so it's not that expensive. And these are some of the nice attributes. So the interesting thing is you can use the R symbol, and the mark is incontestable after 5 years. So if you're infringing on someone else's trademark and nothing has been done for 5 years, then you can keep on using it. That's all it means, which is good. And if you register it, and the registration 10 years, it takes about a year. Some people are quicker depending on the queue for the trademark process. And you can do an international registration through the Switzerland and designate a few countries. So if you have international operation, it's good to do that because especially if someone's using the trademark. Are we doing on time? We can do, I think we're out of time. I can answer additional questions if you have.
Hello. So I was just curious, so when you're doing a patent search, I've heard that if you use well-known services for example, Google or some other service, it's generally not a good idea because that might be giving someone else an opportunity to put you at a disadvantage. I was wondering if there's a better way to search, if is there a recommended way to search for whether a patent already exists?
If you're doing a Google search versus Google search?
Well, I don't know, maybe there's another service or something.
Yeah, you can do the USPTO has the patent database, or the Google is just the extraction of that database.
Okay, so you can directly search USPTO? Right.
Okay. And then you can put various search terms on there.
Okay, so and the other question I had is what prevents someone from filing a patent on some idea they had and not actually implementing it or forming a business around it or anything?
It doesn't stop them.
Is there a time limit they have until which they have to do something with the idea or allow someone else to do something with it?
20 years.
Okay.
If they provide sufficient amount of implementation, then if it's enabling, if it satisfies all the requirements that I've gone through, then they have rights as anybody. Go ahead. Oh, the microphone needs to. The microphone person will ask the question.
Thanks for the great content. My question is about closed claim and open claim?
Right.
Can you have them both in your non-provisional?
Yes, you can have both. But they're going to be independent claims. No. Strike
have
the
them
last
both?
part. You can have both in your patent application.
Okay.
Doesn't preclude it.
And the second question is, let's say if your idea is, you can generalize the idea from one, let's say, space to many spaces. Does it, is it categorized as open versus close, or is it something else?
No. It doesn't matter. It's more of the claiming structure. To when you have open claiming, then they allow broader interpretation.
All right.
Patent
So-
office will try to do a broader interpretation.
So let's say, as an example, I have an idea to save money, let's say in fitness, and this idea is applicable to all other spaces.
Right.
Let's say,
Actually, it doesn't matter on the domain.
Right.
The patent office, if they issue you a patent, you can apply it to as many domains that are reasonable to that you can apply it without changing the underlying technology.
and during that 1 year window that you have to turn your non-provisional to provisional to non-provisional, can you freely speak about it without, you know?
Yes.
Okay.
Yes. It's still, you can do patent pending. That's where it is.
Thank you.
Rob's going to.
So my question is, after you patent an idea and somebody infringes that patent or the trademark, anything that you have registered for that matter, then you need to be able to start a legal fight and put a lawsuit and do all those procedures, yes, to get what your own right should be, supposedly. But my question is, will your services cover all those procedures too, or you'll just help with the patent and filing the patent?
Right. I generally handle the filing of the patent.
All right.
There's a lot of patent litigators out there. You can see from the Google Apple case, that actually Apple Samsung case.
Oh yes, that's
The-
always one of the big news.
Yeah, I don't handle any of the litigation because it requires quite a bit of resources.
Okay,
And
thank you.
so- any additional questions? Go ahead.
So my question is regarding, I saw an exception for mathematical algorithms.
Yes.
And so like in my process, I take open source software to collect data, and then I apply mathematical algorithms and some business logic and come up with a new outcome. I don't understand if that's patentable
can't
because I use a
patent it.
lot of math.
You can't patent the math. You can patent the data structure resulting from it, the whole system,
Okay.
rather than just the math. Math you can't patent. But if you use the math in your technology and put it as part of your system, then you can patent it. What it was saying is math by itself is not patentable.
Sure, because it's just nature.
Right. So, but if it's in combination with other things, sure you can.
Thank you. Two questions.
Last question, because I want to stop at 1:30.
Last
and
two
you can ask
questions,
me.
okay, last two questions.
Go ahead.
So by virtue of practicing this business, this trademark in a local area, right? It's case number one that you presented. It then protects against other people doing that in that local area. But if you file federally that trademark, and although you're practicing only locally from the beginning, it
Right.
protects you nationwide. Is that?
That's right. That's correct.
Okay, second question about copyright. Is copyright statement, whatever that C on the website, is that a full copyright protection or something else needs to be done?
In terms of your website or your
Content, yeah, on the
your
website.
content, yes. As for your content, yes, it is, because it's. But it would be better to register any of that content with the Copyright Office. Send them a copy, registration, but most people don't bother doing that.
But Right, but what's the right thing to do?
right? It depends on how valuable it is. If it's just a website, not that much value, then you don't.
So putting copyright statement on pages of website, what extent of the protection you have?
It gives you, if someone copies it directly, then they've infringed on your copyright.
Well, if they change one word, so it's a reasonable comparison?
Yes, it's a reasonable comparison,
Okay, so it's
that it's a copy.
right. So it's
But the registration gives you, as trademark, copyright registration
I see.
gives you more evidentiary weight
Got
to
it.
your
Understood.
stuff.
Thank you very much.
Okay, and hopefully I finish by 1:30. Thank you.